This is a lecture for professional responsibility, and we're talking about the conflicts of interest requirements for lawyers under 1.7. And this particular video is about this very specific requirement that lawyers have to get consent to a conflict of interest from their clients in writing. And why is this important for my students? Because this type of very specific, almost like binary provision in the rules of when things have to be in writing and when they aren't is a favorite subject for multiple choice tests, like on the MPRE or on my final exam. If you're doing writing multiple choice questions, it's very tempting to write them about specific provisions where there's a clear right or wrong answer. So make sure you're clear in your head about when a lawyer has to get something from the client in writing and when getting it in writing is only optional. And that's what we're going to talk about here for a moment with conflicts. Now, you may remember that 1.7, when it's set in the situations where you can proceed with representation in spite of a conflict of interest, that you have to get informed consent confirmed in writing. And in another mini lecture video, I talk about what we mean by informed consent, the necessity of making sure the client actually understands what they're consenting to, what the implications of a lawyer with a conflict of interest or even an attenuated conflict of interest, what that means. The ABA model rules, though, also have a comment about the writing requirement itself, and we're going to take a look at that. So comment 20 says, paragraph B requires the lawyer to obtain the informed consent of the client confirmed in writing. Such a writing may consist of a document executed by the client or one that the lawyer promptly records and transmits to the client following an oral consent. So there's not a universal form for consenting to a conflict of interest or something like that. It's typically a document, and if you want to cover yourself as a lawyer, have the document briefly explain the nature of the conflict and some of the implications that you've also explained orally to the client, and then have a signature line for the client. There's no requirement of witnesses. You're not doing a will or anything like that, but it should be a document. There could be some situations where you agree to represent someone and you're not able to have them sign a document before you undertake the representation. And an example would be maybe you're talking to someone who's been arrested and they've only called you, and you've agreed to take their case before, and you want to start working on doing some of the legwork. It could be that someone's in a remote location or is quarantined or something like that. So what you can do is agree or get consent to the conflict, explain this in either an in-person or telephone conversation to the client, what your conflict is, and then basically draft a letter recapping your conversation and asking the client to sign that, and or sending it to the client so that you know that they have a written record. If it's not feasible to obtain or transmit the writing at the time the client gives informed consent, the lawyer must obtain or transmit it within a reasonable time thereafter. And so, in other words, don't wait and at the end of the representation when you're sending a nice knowing you letter to the client, say, oh, by the way, please sign this thing. I forgot to have you sign your consent to my conflict of interest. Even if you have to really get right on it with doing some work for the client before you've gotten consent in writing, do it as soon as possible. That's the rule. Don't just, it's not like it doesn't matter when you do it. It should be as early as you can. Now, this is a more thoughtful comment that I want you to think about. The requirement of a writing does not supplant the need in most cases for the lawyer to talk with the client to explain the risks and advantages, if any, of representation burdened with a conflict of interest, as well as reasonably available alternatives, and to afford the client a reasonable opportunity to consider the risks and alternatives and to raise questions and concerns. And so what are we really talking about here? That's a kind of a mouthful. It's all one long sentence. what we don't want is that you hand the client a stack of papers, one of which is a consent to a conflict of interest, and just say, sign all of these. And so they start going through the stack, looking for the signature line and signing it without reading it or really understanding it. And this is a danger. When you tell lawyers get something in writing, the perverse incentive is they get it in writing and then they don't bother explaining it to the client. And the ABA wants to make sure that you understand the ethical duty is that your client actually understands this, and we're having it put in writing to ensure that you've explained it, not to make it look like they've consented, so that you've gotten consent without explaining it. The writing is required in order to impress upon clients the seriousness of the decision the client is being asked to make, and to avoid disputes or ambiguities that might later occur in the absence of a writing. There's sort of a philosophical issue here that could apply to a lot of your other law school classes about writing requirements. And I want to explain explain this for a moment. Think about, from contracts, the Old English statute of frauds, the statute of frauds, where certain types of contracts, even though oral contracts are normally binding, certain types of contracts, they decided at the statute of frauds had to be in writing. So you may remember real estate transactions, certain types of service contracts that were for more than a year, certain types of specific performance things, and contracts for regarding marriage and so forth had to be in writing. And I want you to think for a moment about, why did we require this? What was going on before we had the statute of frauds? Why did they pick a list of things and say this has to be in writing? Well, because these are high stakes transactions as part of it. And so you could have someone, a fraudster, a con artist, could just say, hey, Farmer Brown said that he would sell me his whole farm for $1 or for a bag of magic beans or something like that. And so I want to hold him to the contract. And he could say, well, you're lying. We never even had that conversation. And so because the stakes were high with the things mentioned in the statute of frauds, they pick really things that would be devastating to have someone cheat you out of just because they were a good liar, and it would be your word against theirs about whether you had orally agreed to this very lopsided contract that gave away your livelihood or your labor or your marriage rights or something like that. On the other hand, some scholars noted that the statute of frauds sometimes backfired, and I want you to think about that and how that relates to this. So for just a moment. So if you think about, we need people get things in, we need a signature in part because of the what we might call the forensic problem, or the slide that we had up, the comment says, to avoid disputes later about what was actually said and so forth. So put it in writing, and then it settles it. We don't have just one person's word against another long time after the fact about what kind of conversation actually transpired. So there's this evidentiary issue that is part of it. And one of the ways that this backfires, unfortunately, is that if you can convince someone through coercion or deception, a little bit of deception, or some sort of inducement, or you're just a kind of a good con man or super salesman, into selling you their farm for next to nothing or something like that, and then you get it in writing, it's going to be even harder for them to talk their way out of this unfair, unconscionable deal later than it would have been before, when it was an oral argument, where the forensic dispute sort of overlapped with the sense of fairness. Like, nobody would have agreed to something like that. And if we have your signature, we can hold you to things that we otherwise would have thought nobody would have agreed to this. And so this is a way that sometimes if the statute of frauds actually ended up hurting the people it was supposed to help. And we have that concern here. There's another reason, though, besides just resolving the one person's word against another later on that was about what was said, and that is what's mentioned here. If you make people put something in writing, they're going to take the decision more seriously. And this is especially true for non-lawyers, where if you say, hey, I have a conflict of interest, and you kind of run through it and explain it to them, do you agree with that? Or will you consent? And you say, great, so I need you to sign that you're agreeing to that. All of a sudden they realize, wait, something serious must be happening. Like there must be some serious consequences if you're asking for my signature. And that is what we want. We want the signature requirement not just to cover your back later that you did in fact get consent. We want the signature requirement because it impresses on a client, especially unsophisticated clients, that there must be something serious with a lot of consequences if they're actually being asked to sign something with a legal signature, that this is something they should think about and reflect on and make sure they really understand the pros and cons. And that's the goal here. Again, I want you to see how the writing requirement is really in service to the idea that the client must be informed. We're asking for what the ABA is saying in comment 20 is we're getting in writing because what we really want is that the client knows what they're consenting to. They're not saying we don't want clients to consent or for you to have these consent agreements where you have a conflict of interest, because sometimes it's okay, right? You're a lawyer and you do a lot of different, you do cases for a lot of different insurance companies, Nationwide, Geico, Progressive, and so forth. And those types of lawyers may be, at some point you do a case on Tuesday for Nationwide, and on Friday you're doing a case for Progressive Insurance, and the opposing party is Nationwide's the insurer. And so you may ask the insurance companies to consent to this, and almost all of these cases are going to settle before trial. And so they may just consent to it and say, yeah, you and every other lawyer we hire, all of you are working for all the insurance companies when they give you a case. That's not a big deal. And so that's kind of our classic situation where we actually kind of want consent to the conflict of interest, and then just the work can get done. What we don't want is lawyers taking advantage of unsuspecting clients who don't know any better and don't know what questions to ask. Okay, and that concludes our lecture about the writing requirement.